the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Ms. Chekovich.
Good morning. May it please the court. My name is Tennille Chekovich, and I am here representing plaintiffs' appellants on a pro bono basis today. I would like to continue to reserve 10 minutes of my time for rebuttal. When plaintiffs began this litigation, they had a simple goal: to stop the defendants' unconstitutional suspension of their driver's licenses under Section 46.2-395 of the Virginia Code. After 2.5 years of litigation, plaintiffs achieved that goal when the district court entered its well-reasoned and warranted preliminary injunction. Plaintiffs are prevailing parties because the district court's merits-based preliminary injunction materially altered the relationship among the parties in a way that directly benefited the plaintiffs, and that change was never undone by any court. Consistent with the four-part test this court has discussed in its recent decisions in G and Cities for Life, the preliminary injunction in this case was, first, an appealable order of the court. That second, granted relief on the merits. That third, materially altered the legal relationship between the parties. And fourth, was enforceable by the court. The preliminary injunction upended the status quo. Before the preliminary injunction, plaintiffs suffered ongoing deprivations of their driver's licenses and the specter of hefty reinstatement fees to try to get them back. After the preliminary injunction, they did not. Then, more than 7 months after entry of the preliminary injunction.
As a factual matter, do we have evidence in the record that some of the plaintiffs actually received relief as opposed to just maintaining the status quo? In other words, did some actually get relief following the preliminary injunction that was irreversible?
Yes, Your Honor, they did. So there are findings in the preliminary injunction that specifically address individual plaintiffs who were not able to drive and what happened to them when they were able to. So for instance, it talks about plaintiff Stinney not being able to get to medical appointments and then being able to do so once his license was reinstated. Certainly, plaintiffs did, we know that plaintiffs did have their licenses reinstated by the commissioner. He did comply with the—
Is that in the record?
Well, there are findings that relate to it, certainly.
We're not talking about relating. I mean, the preliminary injunction is forward-looking, but the question, like the BC Circuit addressed this in its case, where it held that a preliminary injunction did entitle somebody to fees because, as a result of the preliminary injunction, there was irreversible, concrete and irreversible relief granted. And so the question is, in order to be entitled to fees, there has to be some relief granted as a final and permanent relief granted as a result of preliminary injunction. And your argument might be a good one if you could demonstrate that some plaintiffs did actually get positive relief following the preliminary injunction and before the case was ended.
Well, I don't think there's any dispute. I don't think the government would dispute that that happened. There wouldn't have been any need.
But you have the burden of showing your prevailing party.
Yes, Your Honor, that's correct. But the district court certainly did not enter a preliminary injunction that was an advisory opinion. The plaintiffs did have their licenses suspended at the time the preliminary injunction was entered, and the preliminary injunction required that those suspensions be lifted.
But it seems to me that you first had to get over our decision in Smith. Then Judge Niemeyer presents a very interesting point, perhaps a good one. But it seems to me that would be what you could then show once you get over the initial hurdle that you can even get it. But as I understand, the problem here is you can't get it because of our previous decision. You're not a prevailing party, but if you can be, at least it can be determined, that would be the substance of a hearing. And that would be interesting for you to then bring in evidence as to how this affected, as I understand, was it 900 and some thousand people?
Yes, Your Honor.
I can't imagine that a preliminary injunction of this didn't affect somebody. It sounds like to me you're prevailing, but if that's an issue, this does not sound like to me it'll be a case in it, but I would think the proof, as Judge Niemeyer points out, could be made. I don't think it would be hard.
Yes.
Yeah, I didn't mean to foreclose what Judge Wynn was just saying, because it seems to me Smythe was applied as a categorical bar. And it seems to me that it's not a categorical bar, provided you establish certain circumstances. And that, I suppose your argument would be that that would be done on the motion for attorney's fees.
Correct. So we are requesting that Smith, the categorical bar in Smith be overturned. And should that happen, of course, we would expect that this court would remand to the district court for findings under whatever standard is adopted that would be made.
Well, but canon is it's the real question. If you have relief that's actually irreversible relief that is actually results from that order, you get fees. If it's temporary relief and it happens to be just made permanent by the legislature, there's an argument there that that's the catalyst. But I think the DC Circuit addressed a preliminary injunction can award prevailing fees when the relief in effect becomes irreversible.
Yes, that's correct. So in the Select Milk case, the DC Circuit found that the preliminary injunction there did constitute the order necessary from the court. And we would say here that there's no difference between the preliminary injunction entered in this case and the Select Milk preliminary injunction. The Select Milk preliminary injunction did involve a very high monetary value. But in this case, the injunction saved the plaintiffs from having to pay the $145 reinstatement fee to get their licenses back. And while that may not seem like a significant amount of money for indigent plaintiffs like the ones at issue here, that was the difference between being able to get their license back and not. And so that $145 fee being waived was a significant relief that was granted in the injunction.
The entry of the preliminary injunction, the district court lifted the suspension of the named plaintiffs. Is that right?
Yes, that's correct.
So that suspension's duration was for the term of the injunction. I guess what I'm getting at, the injunction order the Commissioner of Motor Vehicles to send the named plaintiffs a new driver's license that had no expiration on it, in the sense that it would go beyond whenever the preliminary injunction expired.
No, it did not, because that wasn't necessary to lift the suspensions in this case that were at issue under this statute. So they didn't have to receive a new physical driver's licenses. The issue was, is the license suspended in the system? Is it noted as a suspended license? And when that happens, then the police can pull you over for driving on a suspended license.
But the suspension that was granted in the preliminary injunction was for whatever term the injunction would last.
It wasn't time limited. So it would remain in effect for the entire time the injunction was in place.
Counsel, does your argument depend solely on the four corners of the preliminary injunction order, or does it, in reciting your opening, you talked about that was never overturned? Does it include events after the order, such as the fact, as you said, that it wasn't overturned? Do we look just at what happened at the moment the injunction was entered, or do we look to subsequent events?
Well, under the Soul case, we do have to confirm that the injunction was never dissolved or otherwise removed by any subsequent decision in the case. That's easy to do here. Of course, the injunction remained in place all the way through the litigation. So we don't have a problem that would raise a concern under Soul in this case. But that Supreme Court decision, which does require that there's no dissolution of the injunction, would mean that you would look to some procedural history after the injunction's entered.
The reason that may be important is our G case, the first requirement is that, it talks about a judgment, a consent decree, or some similar order, I think is the language. And the question would be, is it similar if it has to take into account future events? Neither a consent decree nor a judgment, they're final. They don't require future events to either happen or not happen. So could you address that question, please?
In the G case, this court said that a judgment was an order from which an appeal will lie. And that's consistent with case law in other circuits and also the Black's Law Dictionary definition. Yeah. And this preliminary injunction certainly was an order from which an appeal would lie.
So that's how it's similar in your view, is that it's appealable?
Yes, the commissioner chose not to appeal,
right?
But that was certainly an option. I'd like to address the Smith case and specifically why we think that it's appropriate that this court reconsider it at this time. The commissioner argues that the fundamental nature of preliminary injunctions, as discussed in Smith and the Supreme Court's decision in Kamenish, supports the continued use of the Smith standard. But that argument overlooks the ways in which the Winter case significantly altered the preliminary injunction analysis. And it also overlooks the individualized nature of preliminary injunction determinations in different cases.
In preparing this, I didn't quite understand why it's so important to look at the preliminary injunction standard. I mean, it's sure before Winter, there was balancing of various interests, and after Winter, they had the 4 criteria, likelihood of success. But it seems to me the difficulty with Smythe is that the district court in this case thought it was a categorical bar because of the preliminary injunction. And as we've discussed here today, it would seem that maybe there is no categorical bar that a preliminary injunction can't serve on a prevailing party issue. In some circumstances, other courts have found that it can. And so it seems to me, if we found that Smith is a categorical bar, as the district court in this case concluded, then we should probably clarify that, shouldn't we?
Well, certainly up to this point in this case, no one's disputed that Smith was a categorical bar.
Well, that's my point. And if that's so, we should clarify that it's not a categorical bar, shouldn't we? That's your position.
Yes, yeah. Certainly.
Okay, well, that's the first step. And then the second step is, are the circumstances in this case sufficient to grant prevailing party status? And that issue was never determined. We'd have to have the district court make that determination, right?
Well, both the magistrate judge in his report and recommendation and the district court found that aside from the categorical bar, all of the requirements for a finding of prevailing party status were met here. So it's not clear to me that that's absolutely necessary, but certainly if this court clarifies the standard and finds that there's any reason to question whether this preliminary injunction meets the standard, then it should remand to the district court to make additional findings. But I would suggest to the court that the findings in the R&R and in the district court's adoption of that make clear that this preliminary injunction did meet all of the requirements.
Counselor, what do you say? What do you say the standard should be? How should an opinion in this case write?
Well, we think that the court should look first to the Supreme Court language in cases like Farrar And that is what has happened in this court's cases in G and Cities for Life. So the 4-part test that this court applied there should continue to apply. We just should not have the categorical bar that says that preliminary injunctions can never meet that standard. And that's because both there is now a more searching merits-based inquiry under Winter that has happened since the Smith case. And also, if you look at footnotes 8 and 9, where the Smith decision talks about any preliminary injunction standard not being sufficient, I think it's fair to say that that doesn't fairly reflect what happens in preliminary injunction cases today. And so those hearings are very different. They can vary significantly from case to case. In this case, that after years of litigation, when the parties went towards the preliminary injunction hearing, a lot of evidence had been developed. 2 experts testified. There were 4 other witnesses. The court had lots of documents in front of it. This was not an example of a hasty preliminary injunction hearing.
Counsel, can I ask you a question about that? I mean, are you suggesting, do you want us to adopt a standard that turns on that? Is that something a district court would look at on remand? Was this a hasty preliminary injunction hearing, or was this a well-developed one?
Well, certainly, some of the other circuits have talked about issues like that as demonstrating that the preliminary injunction was on the merits, but I don't think it's certainly not necessary. Most of the standards simply say that under the new Winter standard for preliminary injunction, where the court must find a likelihood of success on the merits, that's sufficient to show that the decision is merit-based. And I would suggest to the court that the district court, the court that actually, supervised the hearing and then entered the order, is the best place to make that initial determination. That district court judge is certainly capable of knowing whether
But
he or
the
she.
difficulty with that is, the Supreme Court itself said the judgment had to be final. And so the question is, does a preliminary injunction therefore get disqualified? And the answer would be your position, and it seems to me it's persuasive, that it is not categorically disqualified. But then you have to demonstrate that the likelihood of success, which is not by its nature final, actually became final because, number one, the case became moot. Number 2, people were granted relief as a result of the preliminary injunction. That's irreversible. Those additional criteria seem to me have to be there in order to make the preliminary injunction a final order.
And those were here in this case. So importantly, the district court made findings that amounted to findings of facial unconstitutionality in the preliminary injunction. The court specifically said, the court concludes that section 46.2-395 on its face does not provide a meaningful opportunity to be heard regarding license suspension. So it made a finding of facial unconstitutionality. And
no, but you missed my point. My point is that finding, number 1, was a likelihood of success, and number 2 was temporal to the end of the litigation. So the question is, does that categorically get rid of it? Smythe suggested it did. I suggest that if you demonstrate other factors in connection with the preliminary injunction, it can be a final order that makes you a prevailing party. But you have to show something more than just the preliminary injunction. You have to show that the preliminary injunction had the effect of granting relief in a final sense. And that can be done, I suppose, with the case becoming moot and some people actually benefiting with the relief. But absent that, I think you don't fit the Supreme Court standard. So I don't think it helps much to argue the preliminary injunction address the merits. Sure, it has to address the merits under Winter, but those merits are tentative and temporal.
And both of those things that Your Honor has mentioned, the mooting happening after the entry of the preliminary injunction, certainly that happened here when the legislature adopted a new law that repealed.
That's right. But then my only hesitation is, it seems to me we have to show that relief was in effect granted to permanently to some people. And that wouldn't take much, but it seems to me otherwise, you're categorically saying the preliminary injunction that grants tentative relief and becomes moot, automatically you get, that violates the catalyst theory. And so the question is, the relief has to be linked to the preliminary injunction, not to the legislature. And so the way you show that is to show mootness, number one, which ends the case, and number two, that people actually got relief from it, that was never reversed in the case.
The catalyst theory, though, specifically, it speaks to the question of an order not being entered at all. So in other words, there's been no ruling by the court that the plaintiff can rely on to say, we got a decision on the merits. The plaintiff came in and filed a lawsuit and the defendant changed its conduct. That's the catalyst theory. That's what Buchanan is concerned about. That didn't happen here. And
I know, but let me just take another hypothetical. You have a preliminary injunction and then you have a settlement. Private settlement doesn't go to court. They dismiss the case.
Right. So there are cases that address the settlement situation.
Address that and it's found that's not good enough.
That's right. That's right. Because there's no
So
court
my
order
point
that
is,
continues the relief.
categorically showing the preliminary injunctions you're trying to argue here is not enough. You've got to show preliminary injunction plus.
Okay.
And
So
the question was posed to you, what must be shown? What should we say must be shown?
the settlement concern is that there the parties have reached an agreement and
That's
the
not my
court
question.
has.
Question is, what must be shown in addition?
So here we would say that the fact that the defendant mooted the case after entry of the preliminary injunction is sufficient to show that, because it's essentially involuntary at that point. This is the discussion in Grabarczyk, where once the court has declared the law unconstitutional, the defendant's decision to moot the lawsuit by repealing the statute is sufficient to show that judicial imprimatur. So the very fact.
So your argument is that all you need to show is mootness after the preliminary injunction, and automatically that's the prevailing party.
Certainly in a case like this one, where the defendant repeals the legislation that's been found by the court to be facially
Well, that's my
unconstitutional.
point. Under Buchanan, you can't look at that. You can't look at what the legislature did collaboratively. The order didn't mandate the legislature to do anything. It was mooted because of the legislative action. I don't know why you resist the notion that you follow, say, what the DC Circuit did, which is, seems to me, a perfectly logical approach.
Well, we certainly are not resisting the DC Circuit's decision in Select Milk. We think it's very analogous to this case. And for the reasons in the Select Milk case, the same ruling should apply here.
Just to clarify for here, are you arguing that what makes the relief irreversible, what resolves the dispute, that doesn't have to be a judicial action? You're saying that the court gives some relief in a preliminary way, but it's okay if what makes the relief irreversible is accomplished by a third party.
Well, that is the case in any legislative mooting, for instance. So, you're not going to have, in a legislative mooting case, you're not going to have anyone other than the legislature doing that. So,
Right. I'm just trying to clarify your standard for what the preliminary injunction plus what. And your argument is the judicial imprimatur only needs to be on this preliminary relief, not on the lasting relief.
Well, the preliminary relief was the lasting relief in this case. So there isn't a distinction between.
No, but you said the legislature did it. The legislature gave you the lasting relief here.
Well, we would say that the preliminary injunction was in place for the entire time that it was needed up until the moment when the legislature repealed the statute. That mooted the lawsuit. But
so just to clarify again, you're saying the judicial action, the judicial imprimatur, as Supreme Court has said, is that happens when the preliminary injunction is granted, but we know that that's not necessarily enough to award fees, right? That the Supreme Court, as you say, we have to look at how the dispute actually resolves. How does it end? You're not entitled to fees the day the PI is entered.
Mhm.
But your position is that the judicial action is done. Whatever resolves the case, whatever makes it lasting long-term relief doesn't have to be a judicial action. It could be a third party, you're the legislature.
Right, and we know that's the case because, for instance, the Supreme Court holds that a consent decree is sufficient to give you prevailing
No,
party
they did that.
status.
They distinguished very carefully between a settlement and a consent decree, right? Because the consent decree has the judicial action at resolving the dispute, right? You don't
Right.
have to get everything you want, but the judicial action is involved in resolving the dispute.
Right, but in the case where the legislature moots the law, the opportunity to do that has been removed from the parties in the court by the defendant. And so it's
But
pretty
what if it's
clear.
not the defendant? I guess there's some dispute here about whether it was the defendant. I mean, imagine hypothetically, a plaintiff wants to hold a prayer meeting at a library, public library. Government says no. The court gives him a preliminary injunction, but the next day the library is hit by a meteorite and completely destroyed. Okay, so there's no library. He can't hold a prayer meeting there, but he won the preliminary injunction on the merits. Under your test, he's entitled to fees. But there's, I mean,
Yes, and I would say that's consistent with the congressional intent under section 1988. When something like an act of God completely out of the control of the parties moots a case, that doesn't make the success that the plaintiff has achieved any less. Specifically as it could apply in
so
this
the act of
case.
God resolved the dispute. The act of God is what makes him a prevailing party, not the act of the judge.
In the hypothetical you're giving, that's correct.
It seems to me, you have sort of abandoned the suggestion that really what you have to show is that some of the relief was granted pursuant to the preliminary injunction and that was final. For instance, the licenses were reinstated without the payment of a fee. The fee there is now, that's permanent, that's been, and they got the license back. That might be adequate. To focus on what the legislature did violates Buchanan, I think. And so I think what you really have to do is to demonstrate that some of the relief that actually occurred in this case was irreversible. In other words, because of the timing of it. And it occurred while the case was still pending and before it became moot. But I think mootness itself doesn't gain you much under Buchanan.
Well, I had one because I approached this case perhaps the way you did in bringing this as an additional rehearing, that it was a relatively simple case, but apparently it is not. But as I understand it, the district court felt that Smite categorically barred in a relief here. And so all of the conversation we're having, it never got there. You never got there. No one could get there because Smite categorically barred. Now that might be right or wrong. That's what the direction. And as I understand, the panel sort of felt that way with it. So it seems to me the preliminary decision we have to make is, does it categorically bar it? And if it, in fact, it does, then the question becomes, well, what do we do from there? And that might be a question of, was that a trial court question or is it something we ought to? Because all of the things we're going back and forth on, did you present proof of this, a proof of that? Or does the preliminary injunction, is it merit-based and does it go into settlement? Those are all interesting questions, but we are an appellate court. So so when I approached it, and it sounds like maybe I'm an outlier on this, this was a simple case. Does Smite represent that it was a categorical bar? And what draws me to say it probably is when you read Smite, that preliminary injunction is not much different than here. You had a bunch of, you had ladies who were in aid for families for dependent children. Social Security Act says, oh, you got proof of paternity. You got to go find the husband, the father. If you can't, you got to name everybody you've had relations with and get a name in order to be able to get there. And that preliminary injunction was brought in as to those, as I understand, those named plaintiffs, just like here. And this court says, no, you can't, you're not a prevailing party after that law changed in an instance. So maybe that's kind of where this either takes that two roads down in the woods deal, which way you're gonna go on it. But if we're gonna go down the road that it's not a categorical bar and that you could have done this, but you didn't present the evidence, that's a different path than you couldn't even get there because the district court didn't allow you. Now, am I correct? The district court did not allow you to go there because it viewed it as a categorical bar?
Both the magistrate judge and the district judge held that they could not rule in favor of the plaintiffs because Smith was a categorical bar that prevented prevailing party status in this case. Yes.
So would any of the discussion, would have they made any difference to either one of them if it's a categorical bar?
No, I think, you know, the injunction could have been anything. The result would have been the same in this case in the courts below.
Well, that's why I'm getting confused. Maybe I'm understanding. It's
I think
almost
I'm
though you could have done this had you done this or that, but it's a categorical bar from the appeal that we're taking. And the question is it a categorical bar or not? And when we look at the facts, as I said, it seems to me it is, that seems to be, it could, would the remedy in that instance to be, it's not a categorical bar, go back and decide it in light of what we have here, maybe with some guidance. Is that what you're asking or more?
Yes, I think first we're asking that the court overturn Smith, the categorical bar, and then we think the court should adopt the new standard. We think that the test as applied in all the other circuits, applying the Supreme Court precedent, is sufficient to create that test. And in fact, this court already has a 4-prong.
Well, the difficulty with that sounds simple, but the difficulty is every one of those circuits did a little bit of a different analysis. And the question, I think the hard question in this case is what has to be shown to elevate what is a likelihood of success on a temporal basis, to elevate that to a final irreversible remedy. And the circuits have treated that differently. I advanced the notion that I thought the best response might be the DC circuit's approach. But I don't think you can just say the other circuits have done it. The other circuits have all wrestled with the same problem. What they have agreed on, it's not a categorical bar. And it seems to me, Judge Wynn's correct. The only thing we really need to do is say it's not a categorical bar and send it back. But the question then is, should we give guidance? And if we give guidance, what should the standard be? Now, we don't have to do that, you know, but you're suggesting you'd like guidance. If that's so, then we should have a discussion as to what that guidance is.
Well, other than the Third Circuit, which the commissioner discusses as sort of a preliminary injunction plus, there are none of the other circuits would require anything additional be shown other than that the preliminary injunction was merits-based and that it was decided under the likelihood of success standard and that it was mooted.
That's not
The
completely
Fifth Circuit adds
Yeah, that would.
the Fifth Circuit adds a causation prong, which is different, I think, from what Judge Niemeyer is talking about when you are talking about, do they require something else other than the preliminary injunction?
I'm suggesting that the relief granted has to be identified and not from the legislature, but from the effect of the preliminary injunction. That's what the DC Circuit did. And it seems to me that makes sense. If we all of a sudden say it was mooted and then the legislature changed the law, that flies in the face of Buchanan. And so I don't think we can go there. I think we have to do exactly what some of these other circuits done. And they were searching for an approach that would, in some circumstances, a preliminary injunction does function as a final judgment.
Well, in this case, the preliminary injunction was in place for 16 and a half months before the case was mooted. And throughout that
I know, but
time,
none of this is decided and no standard was applied by the district court. In other words, the district court didn't go into this analysis and looked at what the other circuits were doing and what Buchanan requires and what Sol requires. I mean, Sol is pretty categorical too. You know, it said a preliminary injunction alone did not satisfy it, especially in a circumstance where the permanent injunction was rejected. But
it expressly left open the question in this case. So we would argue, you know, this is now the case where we're going to answer that question. And all of the other circuits have said the preliminary injunction is sufficient if it's merits based, if it's based on the likelihood of
I
success.
respectfully disagree with that reading,
Standard.
because none of them says that's enough.
Well, this case is exactly like Select Milk in the sense that that
Select
fee
Mill
wasn't
focused on
paid.
the fact that the relief granted would have been lost, but for the preliminary injunction. The monetary amount would have been lost because of the timing. Now, that is an important thing. That, in effect, makes the preliminary injunction the main grantor of the relief that was obtained. So you have a plus there. You have a big plus, and I suggest that's pretty rational myself. But I speak only for myself in making that observation. But you cannot just say all the other courts have allowed it when it's mooted. They haven't. They have searched for the notion where the relief is linked, is permanent, and is linked to the preliminary injunction. And you can do that in a bunch of ways. The Fifth Circuit established some kind of causation requirement, but it seems to me that's up for debate. Our court can address that, or we don't need to address it. But you just sort of say that every circuit has said when it's mooted, automatic. I don't think any one of them said that.
Well, certainly if this court adopts a new standard, we're more than willing to go back to the district court, as I've said, and present the evidence that that standard is met. And so on remand, we'll continue to litigate that issue. But I would say that the district court did make some very detailed findings in this case on the preliminary injunction. And so we do think that this court could look at those findings and make the decision.
Well, that's for purposes of entering the injunction, right? That doesn't get you anywhere, because
Well,
the
court-
preliminary injunction is an order that's temporal on its face. And that is not a final, it is a likelihood. So both those standards fail under Supreme Court standards of a final judgment that's appealed. And granting the relief, that's irreversible. And it seems to me that you can get around that. I guess you're unwilling to take that invitation, but I think that's what's required.
On the fee petition specifically, the lower court did make findings about the merits-based aspects of the order. And so there are findings in the record in the R&R, for instance, that say plaintiffs obtained a preliminary injunction that was thoroughly merits-based. Judge Moon's evaluation was anything but a review. There are a series of findings.
Don't you agree that that finding of necessity is temporal and only a likelihood? That's the standard the court had to apply.
No, I don't agree that in this case, the judge's findings on the preliminary injunction were all restricted to a likelihood of success.
That's all he could do.
Certainly, he did find that, but he also found that on its face, the statute did not provide any opportunity to be heard. And under the case law, that is facial unconstitutionality. And he used that words. He said, on its face, this does not happen. And so what I would suggest to the court is that a hearing in this case on, for instance, the permanent injunction with respect to the procedural due process claim wouldn't be any different. The court looked at the language of the statute and applied the law and found that the statute was facially unconstitutional with respect to that procedural due process claim. The proceedings on a permanent injunction would be identical, just as they would at summary judgment or an eventual trial on that claim. I'd like to touch briefly on.
I'm going to help you. Thank you, Ms. Chekovich. Scott.
Thank you, Your Honor. Mr. Chief Judge, and may it please the court, Trevor Cox on behalf of the commissioner. I'd like to focus my time on 3 points about why Smith remains rightly decided and why plaintiffs here are not prevailing parties. First, Smith is consistent with the plain language of Section 1988 and Supreme Court precedent interpreting it. Because of the very nature of the preliminary injunction, obtaining one does not make plaintiff a prevailing party. That was so at the time of Smith, and it remains so today.
So is your bottom line going to be that Smith is a categorical bar when it comes to a preliminary injunction?
Yes, that is the first order argument. I think we still win, even if this court were to create an exception based on what other circuits have held, because we don't think this case fits those exceptions. But I think that the Smith case remains rightly
Well,
decided.
if we were to disagree with you and were able to determine or give guidance as to a different standard, wouldn't that of necessity have to go back to the district court?
I think if this court didn't feel that it had enough in the record to make that determination, then it would have to send it back. It depends on the standard that this
We
court
would be
applies.
applying, just theoretically, we would be applying a new standard never applied before by the district court without findings of fact made under that standing. We'd be doing that in the first instance.
If the court felt that it needed more facts to make that determination, then it would have to send it back. This court would not make findings of fact itself if it were not in the record.
But the district court didn't have a standard. If we were to provide a standard, the district court's findings are in the context of where it found itself. And it seems to me the district court did not give that a great deal of attention because it felt bound by Smith and said it can't go anywhere. It seems to me that if we were to conclude that that is too rigid, that there are exceptions to Smith or to preliminary injunctions, then we should send it back and let the court try to find out and explore what the other circuits have done. Or we could give it some guidance, I suppose, and they could apply. But I don't see how we should be finding facts under a standard that we would determine.
I think it depends on what standard the court chooses. If the court,
Any standard.
well, if you feel that looking at this case, this is exactly like Smith, but we don't want to make Smith a categorical bar saying that you can never get prevailing party status from preliminary injunction. But on the facts of Smith, similar to the facts here,
Well, the
we're not
hypothetical
gonna-
that Judge Agee and I are posing is that suppose we conclude that Smith was too rigid, too categorical, and that there are circumstances where a preliminary injunction can result in award of fees.
sure. So some of the other cases that come up in other circuits are where the defendant basically admits liability or suggests that they're not going to contest the constitutionality of the challenge statute. The courts there have found no problem entering a preliminary injunction and conferring prevailing party status on that ground. We never admitted liability. We continued to think the constitutionality of the statute was clear. And
But
so
no
if that
one-
were
no
the
one in
standard,
this- Might have been Judge Wynn who brought this point up. No one in this case until today, we have this argument based on the briefing, has taken Smith to be anything but a categorical bar. That's what the district court thought. That's what the parties thought. That was the way they litigated down below.
that's right. And what I'm suggesting is if this court decides that it's not a categorical bar and that indeed you can get prevailing party status in instances, say, where the defendant essentially admits liability and consents to the entry of permanent injunctive relief.
Here's where
Then-
it gets confusing. The district court says it's a categorical bar. Magistrate says it's a categorical bar. You now say Smith is still good law. You are essentially saying it's a categorical bar in the story. But you want to say you can keep Smith as a categorical bar, but you still can then say, well, it's not a categorical bar, and you can do these other things. That doesn't seem to follow. And what is being asked here, if we determine Smith shouldn't be a categorical bar, shouldn't be so restraining, what is the test? And so there are a number of circuits. Seems to me the one that's the furthest out is the Fifth Circuit that has gone in this business of, that the preliminary injunction award caused the legislature to subsequently move the claim. Do you go that far? Or where do we go in fishing in trying to come up with a test? That's the reason for the extra question is, do we give guidance to the district court if we determine that first question is not a categorical bar? Sure. But you start out saying, oh, it's good law. And we've all said, everybody's saying it's a categorical bar, but you say it's good law. So how's it good law if it's a categorical bar? We says it's not. So once you get beyond that, then the question is, what is the test? We should try to give some guidance perhaps to the district court, or should we send it back and let the district court work this out and come back up?
Sure. I gather that at least some of the court is not on board with our proposition that it remains good law and that a categorical bar is
We're
consistent.
talking two different things. The district court said it's a categorical bar. The magistrate, the appeal is from that. And you say it's good law. So if you say it's good law and they said it's a categorical bar, are you saying the district court was wrong that it was a categorical bar?
No, I'm saying the district court was correct and you can affirm on those grounds.
That it's a categorical bar.
Correct. To the extent that this court disagrees with that and wants to create an exception, if you think that this case doesn't fit that exception, then there's no need to send it back because you can affirm on that ground too.
It seems to me that your most fruitful use of your time would be to argue. We understand your argument on the categorical bar. The question is, if you were not to persuade a majority of the judges on that issue, what standard would you prefer that the court apply? What do you think is the most consistent with the Supreme Court jurisprudence under Section 1988?
Yes, the difficulty is that Section 1988 promotes the bringing of meritorious cases. And unless there's some finding that the defendant actually violated somebody's rights and that the case was actually meritorious, then attorney's fees should not be granted. And so there has to be a determination that there's actual violation of somebody's rights. Otherwise, it's not appropriate to shift fees. I gather that there's a concern. This came up at the panel stage. It's come up in the Grabarczyk case, as well as Rayo Zudin, that there might be gamesmanship at play. And the court wants to guard against the possibility that a defendant would strategically moot a case to avoid paying attorney's fees. And so if that is the motivating concern that suggests that the categorical bar shouldn't be in place, then I think that the Fifth Circuit standard that links the idea of strategic mooting to the preliminary injunction is the one that makes the most sense.
Counsel, on that question, the Dearmore standard from the Fifth Circuit, what's your position as to whether that standard is consistent or inconsistent with Buchanan?
I don't think it's consistent. It's sort of a modified catalyst theory. And I don't know that it would survive scrutiny by the U.S. Supreme Court.
Because it's
Well, then why would you advance that as the appropriate standard that we should consider? I think your point is well taken. I think that Buchanan basically said if it causes the linkage, that's a legislative action. I think it's pretty clear Buchanan would put in doubt Dearmore.
Because it's the only standard that we've identified among the circuits that tries to meet that gamesmanship concern.
Counsel, can I ask you a question about that? I don't even really understand how it would do that. Like in a case like this, and I'm not trying to make any suggestions about what happened here, but imagine a case that had some similar facts to this one, where the plaintiffs want to go forward to a ruling on the merits before the legislative session that ends up mooting the case. And it's the defendant who gets the stays over the plaintiff's objections that make that impossible. So in a case like that, whether or not the litigation caused the repeal, it's the defendant's actions that caused the case to move out and avoided a final judgment. So I don't even really see how the Fifth Circuit causation standard kind of gets at the concern in a case like the one I've hypothesized. You see what I'm saying?
I think so. Let me try to answer it. First, I want to distinguish between the commissioner on the one hand and the state legislature here on the other hand, two different actors, two different branches of government. And so just because the legislature repealed the statute at issue, that doesn't mean the commissioner was involved in strategically mooting the case. But
you represent the commissioner?
Yes, sir.
Commissioner got the stays that ended up having the effect of moving this case out, right? And then
the commissioner was aware that the General Assembly, as it had in previous years,
for the stays of litigation that had the effect in the end of moving the case out. The defendant, right? Am I misremembering the record?
The commissioner asked for a stay, which the district court granted on the grounds of it wouldn't make sense as a matter of judicial economy to proceed with litigating the constitutionality of the statute that it looked like the General Assembly was going to repeal anyway. because it had been considered in previous years. There had been a sea change in the political makeup of the General Assembly, and it looked like on policy grounds, the statute was going to be repealed. So no point in litigating this.
The plaintiffs wanted to litigate it so they could get a final judgment, and the defendant instead got these stays. So my only, it was really, so I didn't mean it to be such a long question, was just if that's what happened, I don't really understand how focusing on why the legislature repealed the statute kind of addresses the problem of who mooted out this case. Just a minor point. I'm not sure you really are, you know, kind of standing on the Fifth Circuit standard anyway, but it's a question I had about it.
Well, I think it gets back to the gamesmanship concern that seems to be evident in this court's recent jurisprudence. And it makes sense why. You don't want, I think there's valid reason to suggest that regardless of why it's mooted, you don't get attorney's fees. But if you were concerned about limiting gamesmanship, you would want to link the action that moots the case to the case or the preliminary injunction. Otherwise, it's sort of
Counsel-
an act of God situation,
Counsel,
Judge Russell.
Over here, sorry.
Yes, sir.
So why do you say that these actors were, seems like you're suggesting that the legislature and executive independent bodies, I'll admit that, were acting in a vacuum. I mean, the reality is that everybody must have understood what was going on. And whether you want to describe it as gamesmanship or something else, the commissioner certainly understood that the political winds had changed in the legislature. And so it had an incentive to see what would happen. And so in that circumstance, that wasn't any different from the cases that we've been concerned about with respect to gamesmanship. Yeah, and I don't want to use that pejoratively, but that's the reality, right? So why wouldn't a plaintiff be entitled to fees in that circumstance? Because, as Judge Harris indicated, they wanted to litigate.
Right, and to be clear, I'm not using gamesmanship to describe the commissioner's behavior
You said that
in any sense. I'm raising the Dearborn standard because that seems to respond to the court's concern about gamesmanship. So
Well,
I
would you
think
have that consideration? I want to go to the discussion Judge Niemeyer had with opposing counsel on the milk producers case where you have. I'm sorry. Yeah, I thought it was dovetailing with you, but
Go ahead.
So I think the answer to your question, Your Honor, is that regardless of what the reason is for the mooting of the case, the bottom line remains that they never achieved actual success on the merits of their case. It was never decided. All they got was a likelihood of success determination that was part of a provisional remedy that was meant to get the parties to a point at trial when they could actually litigate the case. And so regardless of what the reason was for
Well,
mooting,
that suggests you're back to your categorical bar at that point.
well, to the extent that it suggests that it doesn't matter what the reason is for the mooting, then yes.
so does that, the concern in those questions, is that still present if you look at something like the milk producers case, where there is a tangible benefit monetarily there, arguably a monetary benefit in this case, because of the elimination of the requirement that a reinstatement fee be paid. And that, in those circumstances, monetary benefit is not temporally limited. So there's a specific material, concrete benefit brought that's irreversible by the preliminary injunction. Doesn't that fit a separate category from what you've been discussing in terms of gamesmanship, for lack of a better word?
Yeah, so select milk is, I'll point out that the government there didn't dispute the constitutionality after a certain point, or the alleged unconstitutionality of what was happening. But in select milk, there was a certain amount of monetary funds that were saved. Here it is correct, and I think at some point the commissioner represented that changes were made in the system to reflect the fact that the court's suspensions of the driver's licenses was not going to be enforced as to a couple of the named plaintiffs.
And
so
I'm not suggesting that this case and that case are synonymous or identical in terms of the relief, the argument certainly could be made. But if we're looking for a standard to apply in these types of cases going forward, I took the dialogue that Judge Niemeyer had to establish this additional factor beyond the other factors of a preliminary injunction, that there is a concrete material, not temporarily limited relief that is obtained.
Yeah, and here it was temporarily limited because the licenses were only provisionally given back pending actual litigation of the merits of the case later on. And so the licenses could have been suspended again, depending on what happened later on in the case.
Well, it would be the saving of the fees. This case, without argument, I'd like to press your answer to Judge Agee's question. Would that be an acceptable standard to apply? In other words, without addressing factually in this case whether that was satisfied. In other words, if the relief granted by the preliminary injunction is relief dependent on time, in other words, it would be lost otherwise. The preliminary injunction saves money. It seems to me now at that point, the preliminary injunction is elevated to a higher level, granting permanent relief. In that circumstance, it seems to me that's not a subject number one to gamesmanship, and nor is it subject to the limitations of Buchanan.
It seems to me that any relief that's given that should confer attorney's fees ought to be relief that's given on the merits of the actual litigated claim, and that's the standard that the Supreme Court has identified in Farrar and Buchanan, and so it's difficult.
Well, clearly the order is likelihood of success on the merits. The order says likelihood, and clearly the order is temporal. So at that point, it doesn't satisfy several requirements of Buchanan, Farrar, and all these opinions from the Supreme Court. My suggestion, though, is rather than impose a categorical bar on preliminary injunction because it has those characteristics, the question is, can't a preliminary injunction in certain contexts and effects amount to a final judgment granting relief, as in the DC case?
Yeah, I think once you go beyond the limits that the Supreme Court has put in place, you're a little bit at sea. So I understand why you're struggling to come up with something that makes sense.
And we're trying to get your ideas. You know, we can read all these cases and we can decide whether it should be a categorical bar or not. I think the questioning that you're hearing, though, on both sides is trying to focus beyond a categorical bar. Is very restrictive and doesn't take into account the possibilities that other circuits have found. The question is, should we consider those possibilities in this circuit?
Yeah, one possibility, which seems to make more sense than the others, is that if the defendant gives up the ghost and admits the unconstitutionality or liability, or says they're not going to contest it any further, then it's closer to permanent injunctive relief. You could enter a consent decree or settlement.
That's one possibility.
Or consolidation.
Question, because I see that there's it's hard to kind of anchor this to a standard somewhere, but Seoul seems to be the case closest on point to me. At least it's about a preliminary injunction, and it does leave this question open. But I do wonder if we can get some guidance from that case, because in explaining why a preliminary injunction that is later reversed or dissolved in a final order on the merits doesn't count, the court says it's because at the end of the litigation, the challenged rule remains in place and the plaintiff has gained no enduring change in the legal relationship. And it seems that at least in a case of legislative repeal, neither of those things is true. Right at the end of the litigation, the challenged rule is not in place and the plaintiff has gained an enduring change in these legal relationships. Why wouldn't that be enough? Not under the holding of Seoul, obviously, but under the reasoning of Seoul.
Because the enduring legal change doesn't come from any kind of court order. It comes from the fact that it was mooted wholly apart from the litigation. And so there was no court order that gave them the relief they wanted.
There was a court order that was in place for exactly as long as the plaintiffs needed it. This reminds me of sort of the cases, and the courts do seem to be unanimous on this, the cases on sort of a one-off event, like you get a preliminary injunction saying you're allowed to pick it at this convention. And then it moots after the convention is over, case over, but you had that preliminary injunction for exactly as long as you needed it. And the courts do seem to be in agreement that that makes you a prevailing party. And I guess I'm struggling to see why this case is any different. You had this preliminary injunction for, basically as long as the convention was in town, as long as the statute was on the books. And by the time the injunction is mooted out, there's no longer a statute, there's no longer a convention. It just seems like the same thing to me.
Yeah, I think it's difficult when you base eligibility for attorney's fees on the sort of whether plaintiffs got what they wanted, rather than whether they prevailed on the actual merits of a claim.
But they
So
don't get what they want from the injunction. Let me just give you a hypothetical, which is a little far out, but it makes the point that I'm trying to invite you to address. And that is, you have a person dying, and a member of the family, they want to pull the plug on the man. And a member of the family gets an injunction to stay and said, we believe in natural death, not induced death by pulling the plug. The court issues a preliminary injunction, and they say they link it into constitutional rights to live and all these things of choice. And the preliminary injunction is granted. The plug is not pulled. And 2 weeks later, while the litigation is ongoing, he dies. In that case, the plaintiff got all the relief that the plaintiff wanted through a preliminary injunction. And in that case, under the DC case, you could conclude that that person's a prevailing party, couldn't you?
I think under the reasoning of some other circuits, I don't think it's the right reasoning, and I'll tell you why. First of all, I mean, I don't know if the estate of the individual might have claims that go forward. It doesn't seem like permanent injunctive relief would be an issue in that case, but you could actually come to a final determination.
Some people want the plug pulled and other people say not.
So the case goes forward,
Yeah.
and then you can continue to litigate and figure out what the actual law is. Because
Except that he died, moving the case. He died naturally 2 weeks later.
sure, maybe the estate or the executor stands in his stead to bring whatever claim you're.
Well, my hypothetical is that the relief requested was granted on a temporary basis. And that temporary basis became a permanent basis because of the nature of the relief.
Right.
And so that's really the DC case. And the question is, it's a possibility, I would think, this case, but I'm not sure.
Right. I don't think, and that's why I think it's difficult to look at the relief that was gotten rather than whether they actually prevailed on the merits of their claim. I don't think it's fair to impose attorney's fees on state and local governments unless they have been shown to have actually violated the law.
Mr. Cox,
Yes.
go ahead, you haven't spoken.
Please, Chief, go ahead. No, I defer.
All you referred to
No.
my colleague.
Well, I'm now not
We'll
going.
be a long time being.
You want to ask?
Okay,
I'll ask one.
No, I will go ahead. Let me hurry up.
Yes, sir.
Mr. Cox, you don't have to apologize for your position. I think it's clear what your position is. You don't think that changing or not, you don't think you should be able to get attorney's fees unless on the merits it's been shown that's been a violation, which you make it concomitant with winning. Because what you said it very clearly. You said, no, I don't think you get attorney's fees until you've shown on the merits that the defendant did something wrong. And you don't have to defend that. That's your position, but we're asking you to do our homework. So I don't think you have to apologize for that because that's your position. But can I get to this case? If we decide against your position that it is not a permanent bar, wouldn't you agree that this case here, they did get relief from the executive branch, not the legislative branch? Would you agree with that? Because they lifted, suspended licenses and people could drive. They could take care of their children and get to work and do those things. That's the essence of what they wanted done. And you can't take that back from them. Matter of fact, I think there might be an ex post facto argument that make that even if they didn't win, you couldn't go back and reimpose those because that's part of a criminal penalty. But even in this case, don't you think that at some point this was kind of on steroids where there's a prevailing party by the preliminary injunction. Wouldn't you agree with that? But I know you don't agree with that in terms of philosophy. I don't want to, but wouldn't you admit our court trying to then lift this veil that exists under Smith, you'd have to say that this one would be near the top of it. And wherever we go do it is maybe something less than this is required. But what is your position on that?
I don't agree with Your Honor that that what they got was as a result of a determination of the legal claims in the case. This was.
Let me ask you for one comment.
Yes.
You asked for the stay, didn't you?
Yes.
Well, when you asked for the stay, didn't you insinuate the legislative into this case? Because you're saying, oh no, when the legislative does it, doesn't make any difference. But you asked for a stay so that the legislature could intervene for you and do something. I don't think you have to make it a pejorative or what that is. It's legal strategy. That's period. You don't have to put a pejorative name on it. I think that's, that's not against it. It's not a pejorative. But didn't you insinuate that by saying, let's hold up on getting this merits decision that you want so that the legislature can do something for it that you say they don't get credit for because the legislature did it against Buchanan. So we're arguing on both sides of the thing, and you put that in. You should have said, we don't want to stay. We want to be vindicated because we didn't do anything wrong. But then you elongated this. So isn't that true? Didn't you elongate it?
We didn't do anything.
Why did you want to wait for the legislature to act? And you said that acting has nothing to do with their prevailing or not.
Well, because it was an act of the legislature from building for years. They had entered bills years.
Well, who cares about that? This is the Constitution.
Because
we deal with the Constitution and the executive authority and determine whether or not there's been a violation. We're not the legislature. We don't make laws, and we also don't determine what they need to do. Instead, we answer the question before us, and that is the issue at hand. Is the executive action a violation of the Constitution? But you asked us to stop that sacred duty to wait to see what the legislative branch was going to do, but yet you say that has nothing to do with whether or not they prevail. See, to me, that's rather inconsistent. Go ahead.
Well, I think courts make decisions all the time on matters of judicial economy, and it makes no sense to decide cases that are either being decided by another court or that are going to be mooted because of the repeal of a statute. I don't think it has anything to do with the reflection of our confidence on the merits of the case.
In addressing Chief Judge Berger's question, tell me, how does the Lefferman case play here? Because the focus here seems to be, well, this is a relief they wouldn't have gotten or not gotten. The Lefferman case speaks to a prevailing party being someone who the merits of this claim materially alters landscape relationship by modifying the defendant's behavior in a way that directly benefits the plaintiff. What you're seeing to represent to this court is a case in which 940,000 people in Virginia his license been suspended because it didn't pay court costs. And the case rests upon 4 people not being able to obtain a license and by not having a car, can't go to work. And it's a due process, equal protection, and you got a preliminary injunction. You want to defend a case like that when there are plaintiffs lawyers all over this country that would jump on that case with all fours, and anybody there knows that. That's a powerful case. Whether you prevail or not, ultimately, you got to admit that's a powerful case. This is not a run-of-the-mill case where it's gamesmanship. I heard that word. Who wouldn't take a case like that? 940,000 people in a state of this size do not have that license because they can't pay court costs because they don't have the money. That's their allegation. And if they don't have the money to get to get a license, they can't drive to go to work to earn money to pay the court costs. But you think you got a good case, obviously, that you would have won in the court. Is that your position? You feel strongly you would prevail on that. Has any other court or any other state been a law like that prevailed?
Yes, these challenges have been brought in multiple states. Most recently, the Ninth Circuit shot down a challenge in October. The Sixth Circuit shot it down twice in 2020 and 2021.
And it was on the facts of this case where 4 people were denied licenses, and it's going through the system now. But you think you would have prevailed in Virginia during that time?
Yes, Your Honor.
Well, then why do you have to state it? I'm with Judge Gregory. Why stay it and let the politics that's been playing back and forth for years and years and years? Why do that? You have a good case. You asked for the stay.
I think
Why
all
didn't
the
you just
time,
let it play out? Then we wouldn't be here.
we could have done that, but in the interest of judicial economy, why litigate a statute that's gonna go?
So you won't have to pay
statute that's
attorney
gonna go-
fees.
I'm sorry?
So you won't have to pay attorney fees.
I don't think that ever, well, so here's a point that.
That
if-
was a statement made earlier. I mean, that could be, you asked why.
I
I
don't-
didn't say it was a reason. It could be a reason. You
There was no-
know that Smith categorically bars it. It's a preliminary injunction. The legislature's doing on it. You won't have to pay attorney fees if you just say, let's just stay this, let the legislature do it.
And if there had been a suggestion that plaintiffs could get attorney's fees, they never filed a motion after they got the preliminary injunction saying, we're gonna get fees from this, as they were required to do under 54B2D2B. So there was no thought that attorney's fees would be entering into
There's
this.
no statutory basis for attorney's fees for a prevailing party on this type of action.
Yes, under Rule 54, they could have sought for
You
attorney's
think the
fees.
plaintiffs just got this because they just don't want any money ultimately if they prevail on this?
I don't think I understand.
You
the
don't
question,
think
Your Honor.
that they would seek fees on this if they prevailed on it?
No, I'm sure they have. That's why we're here. That's why we're here.
Well, that's why I said that the reason you would do it is you don't want them to be prevailing parties because you got a case in this circuit that says it categorically bars, at least that's what the district court, and everybody else thinks. So what you do is you move for a stay and you stop it. The question is, did it alter the defendant's behavior that materially changed the case?
So Cox, isn't it true that the legislature changed the law because of Judge Moon's preliminary injunction?
No, there's no evidence that
Isn't
happened.
that true?
It's not. There's no I've seen no evidence that.
Legislative action was directly related to the preliminary injunction issued by the district court.
No, I'm not even sure plaintiffs would go that far, but to even suggest that. There was no. Yes.
You have an obligation of candor to the court.
I'm
I'll
aware of that.
remind you of that.
Yes, Your Honor.
If you think about your answer.
Okay, I'm not aware of any evidence that suggests the legislature was aware of or voted to repeal the statute because of the preliminary injunction or the lawsuit in general. There was a movement afoot for years to get rid of the statute. It eventually got a hold in the proper political spectrum, and it was eventually repealed. That is my understanding of the process.
Chief, with your permission.
Oh,
I
absolutely.
know we're over time, but
We've been over time for a long time.
okay.
Go ahead, Judge Richardson.
I just want to return for a minute, if you would, to Judge Harris's question. I know this is a little bit back, but she brought up the Soul case and its similarities to what we have, and the language that I think she correctly focused on is this language that there was Justice Ginsburg described no enduring relief. But what I was curious about is what you took that to mean, given the facts of Soul, because Soul was a case where the plaintiff sought two things, right? Sought one, to do a display in the national park or whatever park it was on February 14th, and to do them in the future. And they got a preliminary injunction, and the display went forward on February 14th. And that display can't be taken away, right? It is enduring in the way art is enduring. And so it was there. And so that wasn't all the relief that was sought, right? They sought two things. We want to do it on February 14th, and we want to be able to do it in the future. But it was, to use your counsel's, view, right? A direct result of the order from the district court. And it, was permanent in the sense that art itself is permanent. A display is permanent. A protest is permanent. And yet the Supreme Court says that's not enduring, right? In its view, that's not final. That's not irreversible. That's not enduring. And that guidance from Soul, now Judge Edwards in the DC Circuit case didn't have the benefit of that, right? He's deciding 2 years before Soul. But it seems to me that Judge Edwards, if he was deciding this after Soul, would have to say that even a temporary benefit that's irreversible, a public display of art, is, in Justice Ginsburg's words, not enduring for purposes of prevailing party status. It's not enough, right? And so why doesn't that suggest to us that the DC Circuit and Select Milk, while maybe correct at the time, is incorrect now after Sol, and that in fact, when we talk about finality or irreversible or enduringness, right, it requires something more than a change that we might, in the common vernacular, refer to as enduring.
Yeah, there's a lot in there, and I think it makes a lot of sense. I would point the court also back to the Supreme Court's interpretation of the material alteration requirement, which generally in the Texas State Teachers Association says it has to involve the resolution of the dispute. And so it gives that enduring finality.
Because there's no doubt in Sol that, you know, it modified the defendant's behavior, right? They permitted this display to go on in the park that they would not have otherwise done, right? There was no debate that it modified the defendant's behavior. I mean, I'm just trying to figure out the test that we keep talking about. Did it modify the behavior? Was it permanent? But all of those, if you look at the facts of Sol, it modified his behavior. It was an enduring artistic display. And yet for prevailing party status, that's not viewed as enduring by the Supreme Court. And that's the rub I'm having with the Select Milk and all the discussions we're having is they might be all fine before Sol, but after Sol, I have a hard time squaring them.
Yeah, I think it comes down to the requirement that the relief stem from the actual litigation of the merits of the case, because only in that circumstance is it fair to punish state and local governments. When Section 1988 wants to go after violators of law, it has to be actual violators. At the end of the litigation, you determine, did somebody actually violate the law? Some cases, defendants agree early on, yes, we violated the law. We're not going to do it again, or we're going to enter a consent decree. We're going to, we're going to cede to liability. Those things didn't happen here, and unless a defendant does that in a preliminary injunction setting, I don't think that attorney's fees are appropriate.
Well, let me ask you this, just a little bit of a follow-up on the dialogue with Judge Harris and Judge Richardson. If the relief requested is monetary and the preliminary injunction saves some monetary money that otherwise could not be granted in the end because of temporal considerations, it seems to me that's different from what the Supreme Court was addressing. Supreme Court was addressing, I think, something that is put on and can be taken down, and they were looking for future. And the permanent injunction reversed the relief in that case. My question is, when there is no reversal, there's a preliminary injunction, and the relief requested is monetary, for example, and that monetary relief is only given because the injunction catches it time-wise before it fails. In that circumstance, it seems to me that the preliminary injunction now serves a different role. It served effectively a permanent role for that portion of the relief, and that would be part of the dialogue that we talk about Sol and the DC Circuit case. I think it's all very interesting and complex, and I think the biggest help that the two of you can give us is give us ideas of what works and what doesn't work. I gather you're sort of resting fairly firmly on an approach that no preliminary injunction can serve to make a person prevailing party.
Sure. To take your Honor's example, if there's some money saved, but it wasn't saved because the defendant did anything wrong, but instead because the district court entered a provisional remedy that took into account a lot of equities and didn't actually have to do anything with, well, only one of four factors had to do with the merits. And even then was only a likelihood of success on the merits. It's difficult to see that defendants should be liable for attorney's fees when it was a function of.
The prevailing party is always defined by the Supreme Court in terms of relief, not conduct. And so you have to look at what's requested and what's obtained. And so I think a preliminary injunction that obtains relief that's irreversible and permanent effectively is different from a preliminary injunction that could be reversed or just became moot.
I think I would agree if there had been actual litigation of the merits. It wasn't just a likelihood of success, a prediction about what the eventual outcome would be.
Well, the question is, you have a preliminary injunction that addresses merits on a very obviously restricted basis, but it addresses the merits by necessity as one of the factors and grants relief on a temporal basis. That alone is pretty clear would not satisfy the prevailing party standard. But the question is there a circumstance that you could think of where a preliminary injunction would serve as a prevailing party standard? That's the real question in this case.
Yeah, the challenge is that because it would have to be entirely merits based. It doesn't really matter these other things about public interest. And we don't want to lower
the issue is whether it's a final order on the merits and grants some of the relief requested.
Right, a final order on the merits, not a prediction of what the merits are going to be.
No, that's the preliminary injunction. You're right. The question is, in the circumstances of a case, can that effectively become final order on the merits?
Yeah, it's difficult to imagine what would actually transform something that is explicitly just, on an equity-based determination into something that's solely
I'm not
merits-based.
suggesting it's easy. You say it's difficult. I agree. This is all difficult. We're searching for the possibility. I just think to advance a categorical argument that preliminary injunctions, because of their nature, don't satisfy the criteria, might be too narrow. There might be circumstances where that's not true. And we have virtually every circuit providing every circuit that's addressed it, 7 or 8 or 9 of them, that have tried to find their way around those circumstances. I think some of them work, maybe. I think the Earmore case might be running in the face of Buchanan, but
Well, if this court decides that there is some exception to that categorical rule and you find that it's not satisfied by plaintiffs here, then I still think you can affirm. And so I think my position has been pretty well laid out. I'd be happy to answer any more questions.
I think you have made your position very clear, Mr. Cox. Thank you so much. Anything further, Ms. Chekovich?
During the commissioner's argument, with respect to the discussion about the Seoul case, the critical thing that happened in Seoul was that the plaintiff actually lost on summary judgment. So any finding in their favor at the preliminary injunction stage was reversed later on a merits-based decision. And so rather than looking at the question of was the first sort of protest on the beach, was that sufficient? The answer has to be no under Seoul because the merits-based decision was overturned later in the case. But that doesn't mean that that the Seoul case, as Judge Harris pointed out, doesn't provide some guidance for the test. I think it absolutely does. And so when we're thinking about what is the appropriate test to put in place, I would suggest that this court look at the Sixth Circuit in Planned Parenthood, where they said the following: the preliminary injunction altered the relationship between Planned Parenthood and the state during the concrete period of time that the plaintiffs required the benefit of the alteration. In other words, the injunction was in place for the entire time. It was, roughly 12 years, I think, while the statute remained on the books. And then it was actually a third party, the FDA, whose change in their recommendations on the medication mooted the case. But that didn't change the fact that that injunction provided those plaintiffs with concrete relief the entire time it was pending. And that happened here as well. So for well over a year, these plaintiffs had relief from the statute under the preliminary injunction. And it was only when the statute was repealed and they no longer needed relief that the case was mooted. And in terms of the question that was raised about whether it matters that it's the legislature versus the actual defendant, the commissioner who mooted the case. I would point this court to its recent decision in Grabarzis, which says that for purposes of prevailing party analysis, there's no distinction to be drawn between ex parte Young defendants and the legislature in determining whether prevailing party is appropriate. And finally, I would just address briefly the Dearmore case. We agree that Dearmore raises the Buchanan concerns in a slightly different context, but it's the same problem of looking at subjective intent of the legislature or the party doing the mooting. And so it's not consistent with Buchanan, and so we would not recommend adopting the Dearmore standard, which we think would lead to unnecessarily complex fee litigation and open up the possibility for even more gamesmanship as defendants think carefully about what language to use in the statute to attempt to avoid fees, or how to avoid making any public statements, as happened in this case with the legislators that talk about the litigation. For 20 years now, this circuit has categorically prohibited prevailing party status under the facts presented here, and has come to be the only circuit across the country to do so. Smith's categorical rule is indifferent to the justness of the case, the plaintiff's political philosophy, the nature of the federally protected right at issue. So this case affects everyone. Congress enacted Section 1988 to open the courthouse doors to meritorious civil rights actions. And this court has the chance to effectuate that congressional intent by overturning Smith's bright line rule. The PI entered in this case was certainly on the merits and meets the 4-factor test enunciated in G and Cities for Life. When the DMV decides to defend an unconstitutional law and fights at every corner, it has to live with that decision when it loses on a merits-based preliminary injunction, even if the legislature later repeals the law in an apparent attempt to stop the DMV from continuing to incur costly legal fees. Courts around the country would conclude that plaintiffs are prevailing parties, and we would ask this court to do the same.
Thank you, Ms. Secretary. Counsel all, thank you so much for your arguments. We appreciate them. Wish you well. I ask the clerk of the court to take a brief recess of the court to reconstitute the panel of the court.
This honorable court will take a brief recess.